I'll leave it like that.
I've been in town.
You remember how they...
And some of those.
Good morning, everyone. I'm Joanne Britton, and I'm very happy to welcome you to our March Open Wednesday class. Remember, please, to turn on your T-coils and turn off and put away your cell phones so that we can concentrate on our class this morning. But before we get started, we have a special person who is celebrating his 96th birthday on Friday. So let's honor Art Hyman with an enthusiastic rendition of Happy Birthday. Happy birthday to you. Happy birthday to you. Happy birthday, dear Art. Happy birthday to you. Congratulations. And now, on to our class. I'm very happy to introduce to you who maybe don't know who he is, but I think everybody probably does. We welcome back Judge Steve Carroll, Senior District Court Judge, Iowa Judicial District 2. That's quite a mouthful. Who's going to be speaking to us today on, is free speech really free? Steve?
Thank you. Can you hear me? Thank you. It's good to be back again to talk about one of my personal passions, the law, and I'm honored that you let me share this with you on occasion. As you know, last year I spoke about the Second Amendment, and I wanted to give you a brief update on the Second Amendment. Well, it's pretty straightforward. Courts keep ruling that gun regulations, including bans on assault weapons, are constitutional, and most legislatures, like ours, continue to accept the uncompromising position of the NRA that guns are a fundamental right, subject to no restrictions. Why does this occur? Well, generally the litigation's in federal court, not in state court. It's a constitutional issue. Federal judges are appointed for life. That makes them independent. That makes them free of partisan politics. That makes them free of the influence of money. Legislators are not free of what economists call rent. So lest I get in trouble here with the diatribe against the NRA, let me get to the First Amendment. Yes?
What about the young man from Parkersburg? Do you know, is he still...
He's still, as far as I know, Mark Becker, what about the young man from Parkersburg? As far as I know, he's still in the Iowa City Psychiatric Unit, where he would have been had he been found not guilty by reason of insanity.
Right.
So he spends his, I'm told, his mother tells me that he dreams a lot about when he was a child in the acreage near Parkersburg. So that's one way to take yourself out of your present position, close your eyes and think about where you're not. Our focus today is on the First Amendment. I'm going to divide it into four parts. Before I get started, though, I have to give a disclaimer. Judges get in trouble without, trying, and I don't. The opinions I express are my personal opinions. Obviously, they do not represent the opinions of the state of Iowa Judicial branch. I'm expressing my own personal right to free speech today. Here's what we're going to do. We're going to start with the text of the amendment, take a little look at that. We're going to go to the history and purpose of the amendment. Not going to spend much time on that. and then define hate speech, review some cases in this area to give you a feel for it, and then ask the question of whether we should reconsider our current jurisprudential position on hate speech. The colonists who crossed the Atlantic in the 17th century came to us from England, and the state strictly defined what was allowable for discussion in religion and politics. Prior restraint in England was common. What do I mean by that? That's the ability of the state to preclude you from presenting a position before you disseminate it, before you even say something. So that would be like the court granting an injunction saying, Carroll, we don't want you to talk today. That one solid feature of our First Amendment is that prior restraint is no more. That's why I don't think Trump's going to keep Stormy Daniels from talking on 60 Minutes. The theory now is, back in England, to publish you needed a license. Of course, we don't need that anymore. But again, in terms of prior restraint, the other area I can think of is Pentagon Papers. Any of you have seen that movie? What's it called? Post. And when I saw it, there were folks who actually stood up and clapped at the end because it was such a victory for free speech, right? I stood up and applauded. It was a great movie. But I had reservations at the same time that here are some folks that are allowed to publish state secrets. Maybe that ought not be published. But I just ask you this question, those folks who stood up and said, this is great, a victory for free speech, would they also stand up and applaud the Supreme Court's ruling in the Skokie case, where they didn't rule on that, but say the Snyder versus Phillips, the Westboro folks, that's a victory for free speech in some people's eyes. So it depends. The Crown also repressed through the law of seditious libel. What's that mean? Well, it became against the law to publish anything critical of the government. We fast forward to the United States, and prior restraint was no longer in mode, but under the sedition laws, you could prosecute somebody for what they said. So essentially the law was, go ahead, you got a right to say it, but you may go to jail for it. That's what happened. America in World War I entered the war in 1917, passed the Espionage Act, making it a crime to cause or attempt to cause disloyalty or refusal of duty to serve. Well, Charles Schenck, a General Secretary of the United States Socialist Party, sent over 15,000 pamphlets to folks likely to be drafted for the war. He argued that the draft was equivalent to involuntary servitude and therefore a violation of the 13th Amendment. As we go along, you'll see that our Supreme Court has used categories of speech and said some speech is very well protected, other categories are not protected. We'll get into that in a little bit. The court, though, always agrees that the highest protection would go to political speech. So you listen to Stephen Colbert at night or some others, and they're protected because what they're saying, their criticisms are right at the center of the protection of the First Amendment. Well, here's Schenck passing out the pamphlets, don't involve yourself in slavery, and he was convicted. The court upheld his conviction. Justice Holmes enunciated the clear and present danger test. He said, considering the nature of the words and the circumstances in which they are uttered, is there a clear and present danger that the problem identified by Congress will occur? Well, as we look back, I'm going to be stating probably again and again that you got to put these things in the context. So here we're in the context of 1917, World War I. There's a little bit hysteria about getting into the war. So my question is distributing 15,000 pamphlets a clear and present danger to the war effort? Probably not. And look how far we've come. Take a look at the Vietnam protests by comparison. Well, this case is best remembered for Holmes noting that there are limits to free speech. That's where he said, the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater. And of course, the Schenck case, the pamphlet case, had nothing to do with a fire or a theater. But that phrase is often repeated. And of course, it's not totally illegal to shout fire in a theater. There may actually be a fire in the theater. That's a good idea to say there is. Or that might be your lines in a play where you have to yell fire. 2 other people were convicted of espionage cases under the Espionage Act. That was not obviously the last time in our history that loss of liberty at home was related to a perceived threat from abroad. We can fast forward to World War II in the Korematsu case, the internment of the Japanese out on the West Coast. As we'll see, Brandenburg versus Ohio, decided in 1979, 69 overturned the espionage trio of cases. Let's go to the text. It starts out, Congress shall make no law respecting the establishment of religion, free exercise, or abridging the freedom of speech or the press, right of people to assemble. We're going to focus on shall make no law abridging the freedom of speech or the press. We're going to focus just on those words today. I'm going to parse it. What do we mean, Congress shall make no law? What is speech? Speech can be an expressive act, burning the draft card, perhaps, burning the cross. Those are expressive acts, expressive conduct, we might say, and that makes the line pretty close. And abridging is a question. We're talking about hate speech today, so I tried to come up with a fairly good definition. It's speech that disparages a person or a group on the basis of some characteristics such as race, color, ethnicity, gender, disability, sexual orientation, nationality, religion, or other characteristic. Generally speaking, these are immutable characteristics that there's not much choice, personal choice. Well, Congress shall make no law. This is a good starting point because it led the Supreme Court throughout our history to rule that the First Amendment barred only governmental, not private speech. People were upset that when Ivanka Trump visited Des Moines, the billboard company said, you can't run a billboard. I don't know if you saw that in the register. Well, sure, the billboard company could say, we don't want that run on our billboard. It's a private matter, contractual. When James Madison first introduced the Bill of Rights in the House of Representatives, he observed that the great object was to accept out those powers where the government ought not act. Madison predicted the courts would be impenetrable barriers to violations. So the central purpose of the First Amendment was to put strict limits on the authority of the government over religion, speech, and the press, among others. Now, this is different from other Western democracies. I wish we could spend more time talking about that. But why? As Madison said, under our Constitution, the people, not the government, possess the absolute the people, not the government. Well, remember the Second Amendment competing considerations we talked about last year. On the one hand, we had those folks that said that the Second Amendment is there for the purpose of arming a militia and to prevent the tyranny of the central state, federal government. There were others who said we have a fundamental right, personal right, to possess a weapon. Those are the two competing considerations in the Second Amendment. And in the First Amendment, we have two competing considerations. First, those who believe the First Amendment serves the end of liberty, checking governmental overreach into our private lives. Then on the other hand, those who believe the First Amendment should serve to enhance the equality and dignity of citizens. So our First Amendment law has shown a preference for liberty over equality, for freedom from the state, not freedom through the state flowing to us. There's a focus on checking the state, not on the state's treating free speech as a public good to be redistributed to further the goals of equality. Now you take those two interests, liberty and equality, and for me they explain the result in the Citizens United case. The majority opinion focused on liberty, the liberty interest, restraining government. Government's not going to tell us whether corporations can raise large sums of money. If you read the dissent in Citizens United, the dissent focused on equality. There's too much, the money gives the corporations too much voice. Well, it's a pretty close decision, but once again, liberty beat equality. If we go to Canada, and I don't mean literally, although some may be thinking about it. The Canadian Charter, look at this, guarantees the rights and freedoms set out in this subject only to such reasonable limits as can be demonstrably justified in a free and democratic society. Take a look at that. First of all, they're saying we got built-in reasonable limits. There's not the idea that it's absolutist. Freedom of expression. Everybody has these fundamental freedoms: thought, belief, opinion, expression. So the focus is on what rights the people have. Focus is not on restraining the government. Section 15, every individual is equal before and under the law. Canada stresses the equality factor in its equivalent of the First Amendment, with no discrimination. Take a look at this. Subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals. There's a specific statement that what we're about in Canada is to try to get equality of voices. Okay, another statement of purpose. This charter shall be interpreted consistent with the preservation and enhancement of multicultural heritage. Rights and freedoms are guaranteed equally to male and female. Well, note that Canada focuses on the rights of people and guaranteeing those rights. The First Amendment, again, focuses on restraint of the government rather than an imposition of a duty on the government to make our lives better by guaranteeing certain rights. Partly, there's a Canadian case, Keekstra, where a teacher was convicted of anti-Semitic references in his high school course. In Canada, the Canadian Supreme Court spelled it out, and they said, we're not going to accept the America version of free speech because America views itself as a melting pot. We reject that melting pot idea in favor of a mosaic approach. So the drafters of the Canadian Charter wanted to develop a bilingual, multicultural country with a pluralistic mosaic. Well, early on, there's sort of stages in free speech. Early on in our country, free speech was to protect the people against the government. The government was much weaker then than now. And as democracy grew stronger, the free speech threat seemed to come from the tyranny of the majority. Restraints were therefore lifted on speakers, and the focus moved to making sure that speakers were open-minded, want to have a well-informed public. At that last stage is the greatest justification for hate speech. I would say we seem stuck in this stage, but I also think there's another stage evolving with the expansion of feminist theory, critical race theory, which view mainstream speech as inherently repressive, white male-dominated discourse. According to this theory, the principal role of free speech becomes the protection of the oppressed and marginalized groups. I think this theory is gaining some traction. More on that later. Purposes of the First Amendment. Well, this is not the way I planned it, but it's working. It's necessary to deliberate our personal lives together, political speech. We need to decide things because we're the ultimate sovereign. It's necessary to allow for individual human dignity. So we do focus, you'll see comments on human dignity, knowledge, to flourish as individual human beings, we need access to knowledge. We need critical skills to separate the, especially today, the falsehoods from the truth. There's some other functions of the First Amendment. There's of course, the pursuit of truth. This is from John Stuart Mill. I picked up his book on liberty for the first time in years, but he says the discovery of truth is sort of an incremental process. It's pretty slow, but we go back and forth, back and forth. It requires uninhibited discussion. This concept of Mill's was imported into our First Amendment jurisprudence by Justice Holmes, his notion of the marketplace of ideas. There's also the safety valve theory. This is applied by the proponents of the absolutist view. These folks that hate others or express hatred, let them express it. Gets it off their chest, and there won't be more trouble later on. That's the theory. Identification theory. I liken this to when I was a judge up north, and most of the cities were fairly small. We had a couple of larger ones, but identification, we know who the bad people are. And so let the white supremacists speak, because then we know who they are. Serves that function. There's the checking theory. This is sort of a mess right now, but checking theory is that abuses of government can be checked by free speech. That was predominant in the 1960s with Martin Luther King, the protests against the Vietnam War. And today we see the checking theory with, who's MSNBC, what's her name? Rachel Maddow. Just for instance, there are many others, trying to figure out what's going on with our federal government. Here's what I use to think about free speech whenever I've taught civil liberties a couple times. And obviously they are concentric circles. So I think of free speech in this manner. Where would you put political speech? Anybody? Right there. So these are gradations of protected speech. Most protected speech is right here, political speech. Then you move on out. This is outside the protection of the First Amendment. Child pornography is out there. It's absolutely unprotected, as it should be. Liable, if I say so-and-so lawyer is a crook and really takes the funds from his clients, that is per se liable. I've defamed him. Well, you can sue for libel. You know, I can't say, I've got my First Amendment right to disparage that guy. I don't. And later on in a case, we'll get at the concept of group liable, disparaging a whole group. Also out here, something I enjoyed, I can't say I enjoyed it, that sounds terrible. Contempt of court. You know, I have the inherent power to manage my courtroom. So, you know, I had a lawyer come in once without a coat and tie, and I said, you know, you're not appearing here today. And what do you mean? I said, well, you're not dressed appropriately. And he didn't say I have a First Amendment right to appear that way. Usually, I was lucky, 32 years, and I'd send people down for life or for 50 years or 25 years, and they always took it pretty well. I didn't ever have anybody turn to me and swear at me. Now, one of my colleagues, somebody swore at him on the way out, and he said, that's 30 days. So the guy turned and said, well, you swore again. My colleague said, 60 days. I never did that because I figured I just sent him down for like 25 years. I you know, had my say. Pure hate speech, harassment, that's out here. The question is, how do we get there? How can we structure hate speech regulations? Colleges and universities have tried very hard to do that. And I wish we could talk sometime about free speech on campus. It's a little different from free speech out here. So what you want to do, if you're going to make an argument about protected speech, you want to try to draw it to the center and say this is political argument. We will see that in the cases. If you're going to go before the Supreme Court and say this is protected speech, you want to try to move it in there. First case, Chaplinsky versus New Hampshire. Walter Chaplinsky, well, again, before we get started, be mindful of the time, place, and manner of the speech. It's pretty difficult for the courts to regulate the content of speech. Viewpoint, a certain viewpoint is unconstitutional. But the court can regulate time, place, and context. And if you recall, S.I. Hayakawa, who was a general semanticist, wrote the book Language and Thought in Action, and he said meaning is derived from context. And the meaning of a case is derived from its context as well. A couple other prefatory comments. Here's 1025, and I talk about prefatory comments, but I know that strong insults and epithets tend to shock and offend, even if they're not directed at the listener. So a setting like this, a presentation presents a challenge for the speaker, how not to risk offending you, but at the same time, really can't sanitize the language, otherwise you don't get a true feel of what the court was looking at. So I know I'm not going to offend because we're all sort of taking an intellectual look at this problem. Chaplinsky, picture yourself on a beautiful April morning on the public green place in Rochester, New Hampshire, 1940. Chaplinsky is a Jehovah's Witness, which doesn't have a lot to do with anything except he was selling the biblical pamphlets, literature, the Watchtower, Consolation. About a crowd of 50 gathered, and he had a bullhorn and he shouted really offensive things, mainly aimed at Catholics. But Chaplinsky was an equal opportunity bigot. When a policeman showed up to see if a riot was in the making, Chaplinsky said, "You're a blank blank racketeer, you're a damn fascist." Well, officer says, "Well, you're under arrest for disturbing the peace." Now the statute, again, look at 1942, It's illegal to use any offensive, derisive, annoying word. Court said right of free speech is not absolute. Certain classes are beyond. We talked about that: lewd, obscene, profane, libelous. And fighting words. This is our introduction to the concept of fighting words. It's those words which by their very utterance inflict injury. So keep that in mind, that Supreme Court inflict injury. So the argument you can make on hate speech is that hate speech causes some injury, especially emotional injury, or tend to incite immediate breach of the peace, going to cause trouble. It's an objective test. What men of common intelligence would understand would be words likely to cause an addressee, that's the recipient, to fight. And they said, look, the statute prohibits face-to-face words. So we're looking at face-to-face words that are likely to incite violence. And he said, you don't need argument to show the appellation damn racketeer, damn fascist, or epithets likely to cause a breach of the peace. Well, if I walked up with a smile to somebody today and said, hey, so-and-so, you're a darn fascist, that's, especially with a smile on my face, that's not likely to cause a breach of the peace. But this is 1942 context. Well, Shaplinsky has never been overturned. It's been more than 70 years, but there's never been another fighting words case upheld. The court finds other ways to protect them, like overbreadth of the statute. We got time. I'm going to move. So we know fighting words are not protected. What about offensive words? Do we have to listen to them? This gets us to the next. Okay. We've got a couple minutes before the break. One thing you heard there, the commentator and narrator said, the court was afraid it would open the floodgates. And that's an absolutist argument you're going to hear. Well, if we allow this, boom, so much else is going to come in. Where else did you hear that? Second Amendment, NRA. You allow any chipping away at this fundamental right, weapons are going to be confiscated and banned. May not be the same people making it. Usually, for the most part, well, actually liberals are sort of divided. One, they want to protect the First Amendment. On the other hand, they're not so happy with hate speech as well. But, so, this tells us several things. By the way, I was sort of proud of the California Superior Court judge. When Cohn showed up with that epitaph on his jacket, sheriff ran into the judge and said, bring him in, hold him in contempt. And the judge said, no, I'm not going to do that. And the evidence supports that Cohn took off his jacket when he went into the judge's courtroom. Now that's probably what I would have done, is say, you know, that's not appropriate in here, take your jacket off. And, the majority opinion, there's no showing the draft was affected. The burning of the draft card case, the Supreme Court, a guy was prosecuted for burning his draft card. Now that's expressive speech, but the Supreme Court said we have a neutral reason, there is a neutral reason, and that is interference with selective service. Here it's not obscene. We define obscene as, I mean in the law, as something that's not, it's got to be erotic, obscene. It's not face-to-face. He just wore it in the courthouse. So we don't have Shaplinsky involved at all. It's not directed to a person. Didn't walk up and get face-to-face. It's not likely to cause him to be attacked like in Shaplinsky. People don't like it, but most people are not going to attack him for it. It's a motive speech, and as the Supreme Court pointed out, a motive speech can be very persuasive. Now the dissent, which my wife likes, is that it's strictly conduct and not speech. That's a close question. So the takeaway from this is offensive language is protected. By the way, just before the break we have a minute, and I'll tell you that this share something personal that goes on at our house, and that's okay, Wendy. But we have raging debate. We're not raging; they're pretty, it's civil discourse. They're
raging.
Yeah. Thank you. But I tend to be a absolutist, and probably by my remarks toward the end of this, you can see that I'm mellowing on that. And Wendy is fond of pointing out, my wife, Wendy Abrahamson, pointing out how hurtful hate speech can be. Sticks and stones may break my bones, but words will never hurt me. Nothing's further from the truth. Words can deeply, deeply hurt. And I talked about the folks involved in critical race theory. A lot of literature is being produced showing that especially racist speech can create severe emotional harm. So the takeaway again is that offensive speech is protected. Now, doesn't mean you got to put up with it. I've been at places where kids are there and young people will be throwing around F-bombs, and I will go up and say, just come on, that's not appropriate or decent in this situation. Now that gun laws have been pretty much unrestricted, I'm a little bit more reluctant to do that. I don't do it in wintertime when they have coats on. So let's take a 10-minute break, and then we'll return. And hopefully, I want to spend some time on questions. I'll see where I am here. Thank you.
Thank you, everybody, for taking your seats and being patient at the coffee. It was quite a crowd out there, wasn't it? Anyway, we'll continue now. Thank you.
Now we know. Yes. Now we know that fighting words are outside the protection of the First Amendment. We know that we are entitled to be offended as well. Here's a case, Beauharnais versus Illinois, 1952. And if you're a proponent of regulation of hate speech, this is the case you just want to embrace. Joseph Beauharnais was distributing leaflets. He's upset about what he called the Negro invasion of white neighborhoods. And he was passing it around. You can't see this, I couldn't find a good one, but this is where you can sign up and be part of his white nation. 1952, gosh, 50-some years ago, and we haven't come too far in some respects. This is and one thing of necessity we have to do is talk about the statutes that people were prosecuted with. It's a crime to distribute any publication portrays depravity, criminality, unchastity, lack of virtue of any race, color, exposing the contempt. This looks a lot like a Canadian charter. So here's what happened in Beauharnais. The majority, Frankfurter, placed emphasis on the exclusion of libel from free speech protection. The argument was that this is group libel. Remember I talked about individual libel, saying false things about other people. Well, Beauharnais adopted the concept of group libel, saying defamatory things about a whole class of people. And catch this, and Frankfurter said, wow, we're not going to protect this speech because there's a risk to social cohesion. He looks at the equality viewpoint, and then he says we're going to defer to the legislature. Now, Frankfurter really didn't talk much about the equality function of free speech, but this interest has its roots in post-Civil War amendments, as we know, and that would have fortified his decision. Many countries in Europe used the Beauharnais analysis, and if you read some cases under the human rights laws in Europe, you'll see some reference to Beauharnais. Generally, Europe rejects our approach, but they do like this. Now, Beauharnais is an outlier in our First Amendment jurisprudence. It recognizes the concept of group liable, but in no case since Beauharnais has the court considered suppression of hate speech as a group liable in order to protect the public order and the dignity of a certain class. Now, reading the case, once again, context is important. The majority said, you got to think about Illinois' experience. We had, recently had race riots in Chicago. We had race riots downstate, East St. Louis. So they included the willful purveyors of falsehood concerning racial and religious groups promote strife and tend powerfully to obstruct the manifold adjustments required for a free, ordered life. In his dissent, Justice Douglas, whom when I was in law school I really embraced, and then as I got away a little, I realized that he was sort of ad hoc and all over the place. But Justice Douglas conceded that the vileness of the Nazis, and he conceded that, and said that in principle such conduct directed at a race or group should be an indictable offense. Well, then why is he in the dissent? Well, he had other problems with the statute. So in Beauharnais, we see for the first and only time in our First Amendment jurisprudence that the court accepts a government effort to equalize the power of speech by regulating expressions of racism that reinforce social hierarchy and continue to marginalize minority groups. Sort of a leveling function. Now, lest we get too excited about Beauharnais, Nadine Strawson of the ACLU says we should remember that the Beauharnais case was actually used to justify actually used against Jehovah's Witnesses for what a federal court called bitter and virulent attacks on the Catholic Church. Now, so she's pointing out, you can get excited about Beauharnais, but minorities can use it too to oppress other minorities. If you're a supporter of hate speech regulation, your reply is as follows. Contempt and denigration directed at minority group X by minority group Y does not mean we should not be concerned about that defamation of minority group X. Defamation of one minority group by another minority group still may impede what we want, a free, orderly life and protection of the dignity of the citizens. Now this view, Beauharnais does not prevail. Here's a Brennan quote, Buckley versus Vallejo, which was sort of a precursor of Citizens United. Brennan says, the concept that our government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. Now, interestingly enough, the Brennan Institute, I think it's at New York University, named for Justice Brennan, would totally disagree with his viewpoint. They're supporters of hate speech regulation for the most part. Brandenburg versus Ohio, KKK televised a rally, and of course they had a rally, and the media got wind of it, so they showed up to televise it. So they're giving free dissemination of the message. And the person said, personally, I believe the niggers should be returned to Africa, the Jew returned to Israel. Bury the niggers. Digger will have to fight for every inch he gets from now on. To pass constitutional muster here, a conviction for advocacy, he's advocating a position. It's got to be directed to inciting or producing imminent lawless action. That gets at the speaker's intent. That's the intent. We want to cause trouble. And it's likely to produce. There's causation. So you have to have intent. We want to do this, and boom, it's likely to cause what you don't want to occur. Found this. This is called staying just barely within Brandenburg. We might in the future need to resort to violence. Sign up for a phone tree to find out where and when it will take place. So, okay, Skokie. I heard this case did not make it to the Supreme Court. Nazis announced they're going to march into Skokie in '76, I think, or '77. And Skokie, as you might know, has a substantial Jewish population, and at that time had a number of Holocaust survivors. So Nazis wanted to march in Skokie. There were several forms of litigation. First, Skokie got a preliminary injunction against him to march. Well, what's that? Prior restraint. Boom, that's out. And then there was a lawsuit that made it to the 7th Circuit Court of Appeals, the Chicago Circuit Court of Appeals Federal. And it's a very good Circuit Court of Appeals. Now, Skokie, what they did, they had the Beauharnais case in Illinois. So if you're going to craft legislation, it's not, and something passed muster before, it's not really good for you as a lawyer to be really creative. And as a trial judge, my job was to not make law, but follow the precedent. So the Skokie folks said, Beauharnais worked, let's draft our ordinance like that. And, oops. And look at this. The Nazis proposed a single-file sidewalk march that would not disrupt traffic, no speeches, so no really interaction with people. So this is at least logistically not unlike the 26 days march out to Brownells. Single-file sidewalk, public areas. That's okay. Nazis proposed their marching uniform with a banner with swastika, statements such as free speech for the white man and for white America. Okay. This was approved. Nazis were allowed to march. They never did. They made their point and decided to go to Chicago. But this is interesting. Here's where we put things together we've already learned. Nazi armbands, they're okay. Why? Tinker versus Des Moines, the black armband case says that's okay. Messages on placards are okay. Cone, F the draft case, remember that? That's okay. No obscene messages, no erotic content. Village said, and this is interesting, that, and I suppose they're just good lawyering, but Phillips said, we're not going to have a violent response. So they took away that issue of imminent danger of incitement to violence. So I wonder what the outcome of this case would have been if the folks in Skokie had gathered up their AR-15s and said, you allow those Nazis to march, there's going to be violence. Well, then we might be in the Shaplinsky case. But the interesting fact here is that's not what they did. The village came forward and said, no, we're civil folks. We don't expect violence. So there's no violence, no fighting words. March to and gathering in the seat of government. That's another thing the court always points out. Where did the 26 days in action meet for a vigil? Public park. Where did the 26 days march? Public sidewalk. The court you know, it's not like going out and blocking streets. So they said the Beauharnais rationale doesn't apply. There's no tendency to cause violence and disorder. So and that again depended on the village's position. Skokie. So again, we know government may protect from offensive speech, but only when speaker intrudes on privacy at home. So generally, we have to be subjected to offensive speech, but once again, like the Fourth Amendment, the home is a sacred place. Somebody can't come up and come on in our homes and start espousing virulent speech. Or a captive audience. You know, if somebody came in right now, Nazi, took over the podium and said, "I have the right to free speech," we would say, "Yeah, but not right now. This is not your gathering." No captive audience. You can't, here we go, I've said it many times, if they're offensive, you can't prohibit it. And look at this comment. This is from a concurring judge. And I was just shocked. It said, "Words die away and flow like water, leaving no taste, no color, no smell, not a trace. And an exception for these circumstances, though, would not die away." Here we go. This is the old slippery slope argument. Once again, and we know words can hurt, but this was the attitude of a concurring judge on the Eighth Circuit. Sticks and stones will break my bones, but these words are never going to hurt you. Okay. Snyder versus Phillips are expansive protections for speech similar to Cohen's or to the Nazis or to the KKK. Might mean that we find times that we are simply outraged by what occurred. That's what happened in Snyder versus Phelps. March 10, 2006, the Westboro Church, led by the pastor, Fred Phelps. And I'm ashamed to say that, you know, most of his parishioners, by the way, are his kids. I'm not ashamed to say that, but I think 8 or 9 of them are lawyers, and Fred Phelps is a lawyer. We do not claim any of them. They picketed the funeral of U.S. Marine Lance Corporal Matthew Snyder, killed in Iraq. Snyder was not gay, but the church objected to what they saw as a pervasive acceptance of homosexuality in the military and in the community in general. Those are some of the signs. Now keep in mind, these folks were 1,000 feet away from the funeral procession. And another fact is that Mr. Snyder, father, did not see these until the newscast later that day. So Snyder filed suit for intentional infliction of emotional distress. That's a fairly recent tort, a way that somebody can recover civilly. And how does that work? Well, somebody says, "We're going to play a joke on Steve, and let's call him and tell him so-and-so and his family died suddenly." That's intentional infliction of emotional distress. There's a famous Iowa case, Meyer versus Nochter, 1977, where Iowa recognized negligent infliction of emotional distress. A funeral guy, undertaker, what do you call him, Tom? Funeral director, that's it. He got lost on the way to the cemetery with a grieving spouse. They spent an hour and a half looking, and she just went to pieces. She sued for negligent infliction of emotional distress and recovered. So that's what that is. So he, he was awarded almost $3 million in compensatory damages for his distress and $8 million for punitive. That's damages that are designed to sting and change behavior. The court mentioned speech on matters of public concern is at the heart of the First Amendment. The core. Westboro, they said you can do this. They set aside the judgment. The Supreme Court conducted picketing peacefully, public place, public street. Any distress caused by picketing was owing to the content and viewpoint. And there's a sort of a tricky theory, but government should not, according to the Supreme Court, regulate content or regulate viewpoint. So here's some of the messages. America's doomed. Don't pray for the USA. Thank God for IEDs. Just horrible stuff. Priests rape boys. So here's what the court said. While these messages may fall short of refined social or political commentary, I don't know if that's tongue-in-cheek. I hope it is, but the issues they highlight, the political and moral conduct of the U.S. and its citizens, the fate of our nation, homosexuality in the military, are matters of public import. So what they're talking about, these are all things dealing with the heart of the First Amendment. What Westboro said is entitled to special protection. As a nation, we have chosen a different course to protect even hateful speech on public issues, so we do not stifle debate. Now, the argument, counter-argument is that if you're doing a balancing, is that this hateful language does not have much value as speech. What does it do to the public discourse? RAV versus St. Paul. RAV is Robert A. Victoria. He assembled a broken chair leg, set a fire in the fence yard of a black family who lived across the street. 1992. Unfortunately, the Twin Cities, earlier than this, had a history of anti-Semitic notions and racism. Much better now. The ordinance said, whoever, pretty broad, places symbol, object, appellation, including but not limited to a burning cross or Nazi swastika, knows it's going to arouse anger, alarm, or resentment, commits disorderly conduct, guilty of a misdemeanor. He's found guilty. The Supreme Court set it aside. The youngster said the First Amendment protects offensive language. That's what this is. The law is overbroad. Mentioning indicates viewpoint discrimination. Well, that's where the Supreme Court said that the St. Paul folks got in trouble, is that they identified certain things in a very broad statute or ordinance, but they left a whole bunch of other things open for question. So it's under-inclusive is what they're saying. St. Paul said, this isn't overbroad. We know what it's talking about. And under Shaplinsky, it's fighting words. And the purpose is not to restrict expression, but to protect people who are vulnerable. They belong to a group historically discriminated against. That's the equality argument again. It's just not prevailing. Court's decision, it's not neutral. It only prohibited fighting words that aroused anger or alarm. They set it aside. So we don't have fighting words based on political affiliation, union membership, or sexual orientation. The dissent said, come on now, we prohibited prescribed obscenity, child pornography, fighting words, all are content-based. And the sort of the dissent says, this is worthless. Burning a cross on a neighbor's lawn doesn't have much value to society. Why can't we say no and prosecute for it? Virginia versus Black. We're going to have time for questions. Virginia law prohibited cross burning with an intent to intimidate. So, intent to intimidate. And the Virginia law messed up because they said that the mere burning of the cross is prima facie evidence of intent to intimidate. Now, what does that mean to a trial judge? It means that to show intent, all you have to show is that they burned the cross. And the Supreme Court said, no, you're going to have to show intent. You can't use the burning of the cross to infer there was intent. these are things, you know, that a trial judge would appreciate, but two cases, one involved KKK, and they burned a cross at a rally out at an isolated farm. The other case, two guys got together and they said, oh man, the African Americans moved into our neighborhood. We do not like that. Let's go burn a cross and let them know. So one was set aside, one was not. Anybody want to volunteer which? Let's go out on the farm. What's that? Out on the farm, they said, we can't prohibit all cross burning. So out on the farm's okay. Because you don't have the Sherplinsky problem, you don't have face-to-face, you don't have the recipients. The only recipients of the communication out on the farm are those, sort of like burning the cross is preaching to the choir out there. All those KKK people sort of are with it, burning the cross, so nobody's offended. So the court's saying, you want to go out to an isolated farm and do your stupid stuff, racist stuff, you know, have at it, but don't bother us with it. So that's okay. But they said, you can see that I went on to my other, but so it said if there's a true threat, it's not protected. And the true threat was burning the cross on the neighbor's lawn. There's somebody right there. So proximity is important too in these cases. There must be proof of a true threat. Result no conviction for the KKK out on the farm, but conviction of cross burner on lawn upheld. Now, I wish, I read several books on free speech on campuses. This comment is mine. It makes it tough for campus regulation of hate speech. It's not inherently punishable, but by allowing punishment of such speech in the context of a true threat, the court does provide opportunities at campuses to deal with certain kinds of hateful threats. So, epithets, for example, that pose a true threat can be regulated, others cannot. And I qualify that by saying that you know, Grinnell College isn't subject to the First Amendment. It's a private institution. So theoretically, Grinnell can say, we're going to pass codes of conduct that are consistent with what we think is our educational mission. University of Iowa is a different story. The First Amendment applies. Now, it's generally wise for places not subject to the First Amendment to try to conform somewhat with the First Amendment. Well, let's see if we can pull this together with some comments in the next 5 minutes, and we'll have questions if you have any. You can see it's going to be a tough road to hoe for the general prohibition of hate speech. It's generally limited to fighting words, and but if it's limited to fighting words and styled after the Beauharnais case, it just might pass constitutional muster. But so far, laws that attempt to regulate hate speech have a very high burden to pass. We haven't seen them. Sherplinsky tells us that fighting words are outside the protection of the First Amendment. Cohen tells us that words that are offensive are not, I'm sorry, the words that simply offend are protected. So, okay, a couple nice. Fighting words, not protected. Offensive language, protected. Easy test, right? Well, Sherplinsky, let's look to the language. Fighting words are those that are likely to cause the average addressee, recipient, to fight. So my question is, who are the average recipients? Only the people to whom the phrase is spoken? All other people who are angered by the phrase? Persons to whom the words are actually spoken may be more likely to fight. Are they only men? Are they women? Are they children? Consider the situation where there's a big, strong, white young man at a bus stop waiting for the bus, and he directs a stream of insults and racial epithets at the single black person beside him. Doesn't matter if the listener is a strong 29-year-old man, a 72-year-old man on crutches, a very small woman of 50, a child of 9. Well, only in the first instance is violence likely. But the question is, if we're only going to protect it if violence is likely, do the other 3 people have to put up with ugly speech that is designed to insult, demean, and denigrate? But wait! The free speech absolutists point out, hate speech serves as a pressure valve. It is socially useful for the racists to blow off steam. I see you don't agree? To this, the proponent of hate speech regulation would say that this approach places great emphasis on the liberty function of speech and little on the equality function. It's speech of no value and diminishes the dignity of the listener. But, the free speech absolutists would point out, consider Martin Luther King, Malcolm X, the war protesters. Hasn't the First Amendment been the best friend of minorities? We need to keep it inviolate, free, open, unrestricted speech. In reply, proponents of hate speech regulation would argue, don't the present free speech absolutist principles work in favor of the majority? Restricting, not propelling change. And don't we already have exceptions that we pointed out? But the free speech absolutist submits, what about the idea of the marketplace of ideas as a means of getting to the truth, the million idea, and the corollary of meeting speech with more speech? Well, they both support the idea that we get at truth by free discourse, don't they? In fact, conservative economists like to talk about letting the free market work, especially without regulation. Our Supreme Court has imported that economic concept into our First Amendment jurisprudence. But I would submit maybe we've had a market failure when it comes to hate speech. There are not equal actors in the free market speech. Some, those very wealthy, are able to dominate Citizens United. Maybe some regulation is appropriate. But let's fight words with more words. But often those who hurl racial epithets do it because they know they can get away with it. The fellow who drives a pickup truck through campus and shouts nigger does it with impunity. Steve King has a Confederate flag on his desk. He suffers no negative sanction. Often the racist spews hatred only when the odds are in his or her favor. Maybe one-on-one. We have seen what talking back sometimes accomplishes. You get a severe beating or a noose around your neck. Talking back is perceived as challenging that power. Well, what could be the answer to, nigger, you don't belong at the university, go back to Africa? More words, right? How about this? Sir, you do not understand this situation. Prevailing ethics and constitutional interpretation hold that I, as an African American, an individual of equal dignity to you, am entitled to be at this university. Now that I told you this, I'm sure that you're going to think to modify your remark. Probably not. Remember the Beauharnais case? And the court relied on on racial discord in the state. Consider today's context. Our president brought in Steve Bannon, a white nationalist, and Jeff Sessions, who didn't qualify to be a federal judge because of his purported previous racial conduct. Our president has normalized denigrating speech and hateful comments, not ever seen before at that level of discourse in our country. He refers to a senator as Pocahontas. He said the judge hearing the Trump University case was biased because of his Mexican heritage. He tweeted anti-Muslim messages with impunity, while the original tweeters are subject to prosecution in Europe for hate speech. He called for a complete shutdown of Muslims entering the country, said immigrants from Haiti all have AIDS, called President Obama a terrible student. Mr. Obama was editor-in-chief of the Harvard Law Review. He said some of those marching alongside white supremacists in Charlottesville were very fine people. Trump endorsed and campaigned for Roy Moore. He called third world countries shitholes. I have not included any of his derogatory speech outside his time as president. I also point out recently a candidate for the legislature, I think it was Maine, who now has withdrawn his candidacy, referred to a young woman who survived Parkland as a skinhead lesbian. Why do we put up with that? We know hate crimes against Jews, blacks, and Muslims have increased. number of us have posted signs in our yards here in Grinnell, giving a welcome to persons of all faiths, sexual preferences, and cultural backgrounds. That we, think it's necessary to post these signs, I think reveals a pathology of hate in our country. I doubt if you're going to see many of those in Canada. I don't know. Now, I point this out not as a polemic against our president, but to point out that it appears hate speech and denigration of minorities and emphasis on white supremacy have become somewhat normalized in our country. The harms of hate speech are antithetical to the goal of political equality, a precondition for democracy. Cass Sunstein, in his book, Democracy and the Problem of Free Speech, said, people confronted with hate speech may feel silenced. They are reluctant to speak and do not feel heard when they do. In light of this, there is nothing obvious or clear about the view that the First Amendment should ban laws prohibiting racial hate speech. Well, I think the debate whether and to what extent to prescribe hate speech has been re-energized. I got my new Republic yesterday, right on the cover, hate speech regulation in Germany. It was critical, saying hate speech regulation has sort of gone awry in certain respects. But it's a debate, it's a hot topic. Perhaps it's time to reconsider our blind obeisance to an absolutist First Amendment. As I thought when I gave the Second Amendment presentation, and as I thought as I went through this, I think we should all realize that the Constitution is not a death pact we've all taken. Any questions? Yes, ma'am, and I'll try to repeat it.
Could you comment on the 3 words, lock her up?
Yeah, lock her up. And comment on 3 words.
I believe Michael Flynn first used those during a campaign speech, and then there were buttons, and it was chanted regularly.
Yes. Lock her up. That's going to be protected. It's offensive. It's Democrats are right. Hillary supporters are not there, obviously, so it's not likely to incite violence. It's protected by the First Amendment. But to say something's protected by the First Amendment doesn't say that it contributes much to social discourse. And that's what we're lacking today, is that in years past, we sort of marginalized the hate groups. We made it known, hey buddy, you're not getting any traction here. Go ahead and spew your hate, but we're not listening. I recommend when I disagree on things, I'll say, well, hate speech, I just don't go. If I know somebody's going to say that, I have the ability to stay away. So lock her up, protected, good idea, no. And it's also sort of consistent with what might happen in Romania or Russia.
But
Yeah.
it's not a comment, it's inciting people to, in fact, do something.
Yes.
So it seems that it passes that line.
And I don't disagree. It's advocacy, and if you remember the advocacy case, it's got to be imminent lawless action and designed to do that. Now, I would say, and I think you've got a great point. If Hillary Clinton showed up at that rally, I think you'd be right on the mark. But they're using lock her up to show their disdain for her, and so I think if a group, there's a Democratic rally for Hillary Clinton, and a group of the lock her up crowd shows up and started yelling at, then I think you're on the mark. But otherwise, we got to put up with it. Turn off. Yes.
In your example at the bus stop with the cripple or the little lady, if they were packing, would that change the outcome?
Yeah, the bus stop, if they were packing, would that change the outcome? Might equalize the situation, yes.
Demonstrate that it was likely to cause violence.
Yes. Yeah.
So now they're capable of it.
Now they're capable of violence. So yeah, you've taken this situation and then we get into the question of conflict between the Second Amendment and First Amendment. Do we want to equalize voices by arming them? I'm serious. Look at Charlottesville. I think we ought to say you can march, but you can't carry AR-15s when you do it. That's a good question. Yes.
The phrase free speech has been extended to many things in addition to human utterance. But I wonder, there are some laws that are known to me only as libel laws. Don't they apply only to written discourse?
Libel would be written, yes, and slander would be the verbal equivalent. So
we have slander laws?
Pardon?
Do we have slander laws?
Yes, they're under the defamation is impugning somebody's character and damaging it, reputation. And if it's done orally, it's slander. If it's done in writing, it's libel. So it's a technique. So if you're at a table and have too many drinks and you make a comment going to the heart of somebody's profession that's negative, you've slandered, you can be sued. Or you can do it in writing if you really want to record it. So.
Would you say a little bit about Citizens United in the matter of money as speech?
Citizens United. I thought that question would come up, so I took a look at it. And in the matter of money, is that correct recitation? Citizens United, I think I can sum up by saying, I go back and forth on Citizens United. I have to share with you, I really did not like it when President Obama, in his address to the nation, took off on the Supreme Court, saying it's one of the worst decisions. It's not very respectful of the court. But to answer your question, the majority said corporations should have a voice, and the minority said, yeah, but things are sort of unequal anyway. You're gonna, there's a thumb on the scale already. You're putting a bigger thumb on the scale for the corporations. So again, one way to think about it is the majority opinion really focused on liberty. We can't prevent corporations from having this speech. In the minority position with 4 justices, looked at equality. We got to try to make an equal level playing field. And the majority came back and responded to the minority saying, yeah, but you're thinking of all these big corporations with a lot of money, and there are many small family-owned corporations, and so it's not going to be the problem that you say there is. I'll share that I've read some stuff that indicates that the amount of money raised through corporate contributions is pretty minuscule compared to the total amount of money. So I don't think Citizens United, I could be wrong, don't think it's been the precursor of corporations ruling. Having said that, the Koch brothers and NRA tend to bring in cookie cutter legislation, and that's a huge problem. I go back and forth on Citizens United. One more, is that? I don't know. I need to stop. Okay, I need to stop. We can talk afterwards.
I'm sorry to cut it off, but we're already past time. Thank you so much for coming today and sharing. So before you leave, remember to turn on your cell phones and turn off your cheek coils, and come back next week to hear the first class of Dr. J.R. Paulson on mental health. See you next week.